Hello and welcome to the Daily News Simplified, the why, what, and how of newspaper reading. Today we will discuss the Delhi edition of The Hindu newspaper dated 16th May 2018. So let's start. There is an article on page number 6 which reads 6 tigers from MP to be relocated to Odisha. This article relates to the shifting or relocation of tigers from MP to Satkosia Tiger Reserve in Odisha. This topic will fall under the preliminary examination syllabus under the topic General Issues on Environment Ecology and Biodiversity. Previously, in the year 2017, a question was asked on a proposal to translocate some of the lions from their natural habitat in Gujarat. So, under this article, we will understand the tiger reserve to which the tigers are being relocated, and we will look at the geography of the Satkosia Tiger Reserve. The tigers are being relocated from Madhya Pradesh to the Satkosia Tiger Reserve in Odisha. Now we will look at some basic facts related to the Satkosia Tiger Reserve. The Satkosia Tiger Reserve falls in the state of Odisha. As we can see in the map, the Satkosia Tiger Reserve is located in the Angul district in the state of Odisha. Another important fact related to Satkosia Tiger Reserve is that the river Mahanadi passes through this tiger reserve. Also, the location of the tiger reserve is at the 22-kilometer long gorge formed by the river Mahanadi in the eastern Ghats. As we can see in the map, the river Mahanadi passes through the Satkosia Tiger Reserve. The major plant communities of Satkosia Tiger Reserve are the moist deciduous forest. And the important plant of this tiger reserve is the sal tree. In the year 1976, Satkosia Wildlife Sanctuary was created, and in the year 2007, Satkosia Tiger Reserve was created. This tiger reserve includes two wildlife sanctuaries. They are the Satkosia Wildlife Sanctuary and the Baisipalli Wildlife Sanctuary. So we have learned that the tigers are being relocated from Madhya Pradesh to Satkosia Tiger Reserve in Odisha. The location of Satkosia Tiger Reserve is in Angul district in Odisha. The famous river that passes through Satkosia Tiger Reserve is the river Mahanadi, and it is located at the 22-kilometer long gorge formed by the Mahanadi in the eastern Ghats. The flora of the Satkosia Tiger Reserve is moist deciduous forest, and the important tree is the sal tree. Satkosia Wildlife Sanctuary was created in the year 1976, and in the year 2007, Satkosia Tiger Reserve was created. This tiger reserve includes two wildlife sanctuaries. The first is the Satkosia Wildlife Sanctuary, and the second is the Baisipalli Wildlife Sanctuary. Another important fact related to the Satkosia Tiger Reserve is that it is a meeting point of two biogeographical regions of India. These regions are the Deccan Plateau and the Eastern Ghats. Now, from prelims point of view, this topic becomes important because previously in the year 2014, a similar question was asked, and in the year 2017, a similar question was asked based on the link between the Eastern Ghats and the Western Ghats from the ecological point of view. With this, let us move on to the next article. There's an article on page number 10 which reads Rohtagi joins Lokpal selection panel. The article further reads that the former Attorney General Mukul Rohtagi has been appointed as eminent jurist. So this news is important because the filling of slot of eminent jurist is a significant step in the appointment process of Lokpal as per the Lokpal and Lokayukta Act of 2013. So under this article, we will understand the purpose, aims and objectives of the Lokpal and Lokayukta Act 2013. We will also understand the composition of the Lokpal body. Further, we will understand the composition of the selection committee, that is, the Lokpal selection committee. Also, we will understand the tenure of the members of Lokpal body. And finally, we will learn about the process of removal of the members of Lokpal body. This topic forms a part of General Studies Paper 2 under the subtopic Statutory Bodies. The purpose of the Lokpal and the Lokayukta Act of 2013 is to form a body which inquires into the allegations of corruption against certain public functionaries. For this, The Lokpal and Lokayukta Act of 2013 provides for the establishment of a body of Lokpal for the Union and Lokayukta for the states. Further, it applies to all public servants inside and outside India. Next, let us understand the composition of the Lokpal body. So, the Lokpal and Lokayukta Act of 2013 says that Lokpal shall consist of a chairperson who is or has been a Chief Justice of India or has been a judge of Supreme Court or an eminent person. Further, the Act says that such number of members not exceeding 8, out of whom 50% shall be judicial members. So the important points that come up are the chairperson shall be a retired Chief Justice of India or has been a judge of Supreme Court or an eminent person. Further, the number of persons in the Lokpal body will be 8 and 50% of these 8 members shall be judicial members. Further, the Act provides for certain restrictions on who cannot become the member of the Lokpal body. The Act says that the chairperson or a member shall not be a member of parliament or a member of legislature of any state or union territory. Second, a person convicted of any offence involving moral turpitude. Third, a person of less than 45 years of age on the date of assuming office as the chairperson or member. Fourth, a member of any panchayat or municipality. And fifth, a person who has been removed or dismissed from the service of union or a state. So the Act clearly says that the chairperson or the member of Lokpal body shall not be a member of parliament or state legislature or the panchayat or municipality and should not be less than 45 years of age and should not have been dismissed from the service of union or the state government. Next, we will look at the appointment procedure and the composition of the selection committee. So the Act says that the chairperson and the members shall be appointed by the president after obtaining the recommendations of a selection committee. So the appointing authority is the president and he appoints the chairperson and members based on the recommendations of a selection committee. So let us look at the composition of this selection committee. The chairperson of this selection committee is the Prime Minister of India and the members include first, the Speaker of the House of People, that is the Lok Sabha. Second, the Leader of Opposition in the House of People, again the Lok Sabha. Third, the Chief Justice of India or a judge of Supreme Court nominated by him. And finally, one eminent jurist as recommended by the chairperson and the members. So in the present news article, former Attorney General of India has been appointed as the eminent jurist as the member of the selection committee. The Lokpal Act 2013 also provides for the tenure of the Lokpal, that is, the chairperson and the members of the Lokpal body. The Act reads, the chairperson and every member shall, on the recommendations of the selection committee, be appointed by the president by warrant under his hand and seal and hold office as such for a term of 5 years from the date on which he enters upon his office or until he attains the age of 70 years, whichever is earlier. So the tenure of the members of the Lokpal body is normally 5 years or the upper age limit of 70 years. Now the removal of members of Lokpal body. The 2013 Act reads that the chairperson or member shall be removed from his office by the order of the President on the grounds of misbehavior. The member shall be removed after the Supreme Court on a reference being made to it by the President on a petition signed by at least 100 members of the Parliament has on an inquiry reported that the chairperson or such member ought to be removed on such ground. Now let us understand the removal of Lokpal in simple terms. First, the removal procedure is initiated if 100 members of Parliament asked for the removal of the members of Lokpal body in a signed petition to the President. Based on this petition, the Supreme Court conducts an inquiry and based on the inquiry, if the Supreme Court has recommended the removal, then the Lokpal members are removed by an order of the President. The President may also remove the chairperson or members if he or she is. The Act further provides for the grounds of removal of the members of Lokpal. These include if he or she is adjudged and insolvent or engages during in his term of office in any paid employment outside the duties of his office and is in the opinion of President unfit to continue in office by the reason of infirmity of mind or body. Under this article, we have learned that the Lokpal and the Lokayukta Act of 2013 provides for establishment of a body of Lokpal for the Union and Lokayukta for the states. This body is created to deal with the corruption cases pertaining to public functionaries. Further, we learned about the composition of the Lokpal body. We also learned about the selection committee and the appointment procedure. We looked at the tenure of the chairperson and the members of the Lokpal body. Finally, we learned the removal procedure of the Lokpal members. Previously, in the year 2013, a question was asked based on Lokpal. We have learned certain basic facts related to the Lokpal body. With this, let us move on to the next article. The news article on page number 1 is related to the Karnataka Assembly elections result. The Karnataka Assembly election result has given out a hung assembly. That is, no political party has attained the simple majority mark. Now, due to this hung assembly, the focus has now shifted on the governor of the state, who will act under his discretionary powers. So, we will understand the discretionary powers of governor under such a situation. Also, we will look at some of the recommendations of various commissions on how the discretionary power in such a situation should be exercised. The functions and the powers of the governor fall under the General Studies Paper 2 of the mains examination, under the topic Power, Functions and Responsibilities of Various Constitutional Bodies. The governor is said to exercise the discretionary power when he is not acting on the advice of the Council of Ministers. Further, the discretionary power of governor in case of a hung assembly has not been mentioned in the constitution. This point needs to be noted because the other discretionary powers of the governor have been mentioned in the constitution itself. So the discretionary power of governor in case of a hung assembly is known as the situational discretion. The governor exercises the situational discretion in case of, first, the appointment of chief minister in case of hung assembly, or when the CM in office dies without no clear successor. Second, in case of dismissal of council of ministers when a no confidence motion has been passed in the state assembly. And finally, in the case of dissolution of state legislative assembly when the council of ministers has lost the majority and no other political party has the numbers to form the government. So the situational discretion is exercised in case of appointment of CM in case of a hung assembly, dismissal of council of ministers when a no confidence motion is passed, and finally the dissolution of state legislative assembly when the council of ministers has lost the majority. In the past, in the exercise of situational discretion, a lot of controversy has been created. To solve the controversy, the Sarkaria Commission has given the following recommendations. The Sarkaria Commission was set up in 1983 to examine the relationship and the balance of power between the central and the state governments. The Commission also dealt with the role of governors and suggested that in choosing a chief minister, the governor should be guided by the following principles. The first principle says that the party or combination of parties that command the widest support in the legislative assembly should be called to form the government. Thus, any party or combination of parties, that is, coalition, which has numbers which show a majority in the legislative assembly should be called to form the government. The second recommendation provided by the Sarkaria Commission was that the governor's task is to see that a government is formed and not to try to form a government that will pursue policies that he approves. That is, the governor should act in a non-partisan manner and his first priority should be to see that a government is formed. Further, the Commission recommends that if no party has a majority, the governor has to invite first a pre-poll alliance, that is, an alliance that was created before the elections. Second, the largest single party that is able to gain majority support. Third, a post-election coalition that has the required numbers, that is, any coalition created after the results of the elections are declared. Fourth, a post-election coalition in which partners are willing to extend outside support. The Commission further recommended that whoever is appointed as the Chief Minister must seek a vote of confidence in the Assembly on the floor of House within the 30 days of taking over. And finally, the Commission says that the Governor should not resort to mechanisms where determining of majority of the government is done outside the Assembly. That is, the determination of majority should be done on the floor of the House. In 2006, in a Supreme Court verdict, a 5-judge bench held that if a party with the support of other political party or other MLAs, stakes claim to form a government and satisfies the governor about its majority to form a stable government, then the governor cannot refuse formation of such a government. In the recent elections held in Goa, Manipur, and Meghalaya, the governor did not invite the single largest party to form the government, but invited a coalition of political parties which assured of a stable government. In the year 2007, Panchi Commission was formed by the government to analyze the center-state relations. The commission recommended that there should be clear guidelines for the appointment of chief ministers so that there was some sort of regulation on the discretionary power of the governor. The commission said that a pre-poll alliance must be treated as one political party. It further laid down the order of precedence that the governor must follow in case of a hung house. In case of a hung house, the governor should follow the following order of precedence. First, group with the largest pre-poll alliance commanding the largest number. Second, the single largest party with support of others. Third, post-electoral coalition with all parties joining the government. And finally, the post-electoral alliance with some parties joining the government and the remaining, including the independents, supporting from the outside. Thus, in the conclusion, thus providing a majority on the floor of the House, either as a single largest party or as a coalition of parties, becomes an important criteria. Also, the governor must be satisfied that whoever he picks must prove their majority on the floor of the House. Now, this topic becomes important because previously in the year 2014, a question was asked on the discretionary powers of the governor of the state. Also, in the year 2003, a question was asked, explain the discretionary powers of the governor of a state. With this, let us move on to the next article. There is an article on page number 8 which reads, At last, a scheme. Now, this article relates to the interstate river water dispute between Karnataka and Tamil Nadu over water sharing of the Cauvery river. Now, the interstate river water disputes fall under the General Studies Paper 2 of the mains examination syllabus under the subtopic Issues and Challenges pertaining to the federal structure and dispute redressal mechanisms and institutions. Now, let us understand why is this article in news. It is in news because the central government has framed a draft scheme on distribution of water of Cauvery river. Previously, Supreme Court in its judgment of February in 2018 had directed the central government to draft a scheme under the section 6A of the Interstate River Water Dispute Act 1956. The scheme was to be drafted within a span of 6 weeks to implement the tribunal's award. The section 6A of the Interstate River Water Dispute Act 1956 reads, Central government may, by notification in the official gazette, frame a scheme or schemes whereby provision may be made for all matters necessary to give effect to the decision of a tribunal. The central government, in accordance with the section 6A of the Interstate River Water Dispute Act 1956, has submitted a draft scheme to the Supreme Court to implement the final decision of the Cauvery Tribunal on water sharing between the riparian states Karnataka, Kerala, Tamil Nadu and Puducherry. The point that should be noted here is that although the river Cauvery passes through only Karnataka and Tamil Nadu, the riparian states are Karnataka, Kerala, Tamil Nadu and Puducherry. This is because the river water sharing takes into account the Cauvery basin. That is, it also takes into account the tributaries of the river Cauvery. Now let us understand the details of this draft scheme. First, the draft scheme has proposed the formation of a 9-member authority to monitor the implementation of the Cauvery Tribunal's final award. However, the draft scheme has not provided any name to this 9-member authority. Further, the said authority shall be a 2-tier structure. The top tier will be an apex body having power to ensure compliance with the final award, and the tier 2 body will be the Cauvery Water Regulation Committee that will monitor the field situation and the water flows. Now let us understand the power and functions of these authorities. The authority will have 5 nominees of centre and 4 of the parties to the dispute, that is, the members of the riparian states. Further, this authority will supervise the operation of reservoirs and regulate water release with the assistance of Cauvery Water Regulation Committee. The Cauvery Water Regulation Committee is tasked with collecting details about the inflows and storage positions of the reservoirs across the states. Further, The powers of the authority would extend to apportionment, regulation, and control of Cauvery waters, supervision of the operations of reservoirs, and regulation of water releases. The most important point is that the authority's decision will be final and binding on the parties. However, if the authority finds that any of the states is not cooperative, then it can seek the center's help and center's decision will be final and binding in such a case. So this discretion provided to the center in case of a dispute can act in two ways. Now in case of a dispute between the states, the discretion of the center will act as an enabling clause for the purpose of speedy resolution of the dispute. That is, it will act in a positive manner. Also, there will be scope for the center to intervene on behalf of the states. However, this can at times turn controversial given the multi-party setup of our democracy. Thus, it can have negative consequences. Further, there is difference between the Cauvery Management Board proposed by the tribunal and the authority as suggested by the central government. The tribunal favored the chairperson being an irrigation engineer with not less than 20 years of experience in water resource management. However, under the authority proposed by the center, the chairperson could be a senior and eminent engineer with wide experience in water resource management or an officer in the rank of secretary or additional secretary to the union government. Thus, the center under the draft scheme has more discretion in terms of appointment of a chairperson of the authority. Finally, concluding, the article says that for the proposed authority to function independently, it is important that it remains autonomous and not under the control of central government. Further, it says that it is equally important for all the riparian states to agree unanimously on the proposed draft scheme for its effective implementation. Previously, in the year 2002, a question was asked based on the interstate river water disputes. The question read, under what article of the Constitution can the Union government play its role in settling the interstate water disputes? So the answer to this question is that under Article 262, the Parliament may by law provide for adjudication of any dispute or complaint with respect to the use, distribution and control of waters in any interstate river water and river valley dispute. With this, let us move on to the next article. There is an article on page number 8 which reads, a triple blow to job guarantee scheme. The article talks about the lacunae in the implementation of Mahatma Gandhi National Rural Employment Guarantee Act, MGNREGA. So we will understand this article under the General Studies Paper 2 syllabus under the subtopic Welfare Schemes for Vulnerable Sections of Population by the Centre and the States and the performance of these schemes. Also, under the General Studies Paper 3 syllabus under the subtopic Indian Economy and Issues Relating to Employment. The article focuses on the lacunae in the implementation of MGNREGA. The author further explains the reasons for the poor implementation of MGNREGA. These reasons include, first, the lack of sufficient funds, second, the rampant payment delays, and third, the abysmal wage rate, that is, a poor wage rate. The author further elaborates and says that many provisions of the NREGA Act are not being implemented in spirit, mainly because of lack of funds. Also, the lack of fund has led to the subverting of the original provisions or the intended provisions of the NREGA Act. The reason for lack of funds is that the budget allocation for NREGA over the years has been insufficient or it has decreased. In real terms, the budget allocation of NREGA has decreased in the year 2018 and 19. In real term means after adjusting it for the inflation. The author further explains that every year the states submit a labor budget to the center specifying the labor demand for the next financial year. However, the approved budget by the center is much lower than what is demanded by the states. This reflects curbing of the work demand. Elaborating on the lack or delay of payment of wages, the author says that the lack or the delay of payment of the wages has violated the provisions of the NREGA Act. The reason for this lack or delay of payment of wages are the infrastructure bottlenecks, unavailability of funds, and the lack of administrative compliance. The author provides reason for the poor wage rate under the NREGA Act. The author says that this has happened because of delinking of NREGA wages from the Minimum Wages Act 1948. Due to this decrease in the wage rates, the vulnerable sections of the society, such as the Dalits, women, and Adivasis, are forced to take up hazardous employment at very low wages. Thus, the article explains the lacunae in the implementation of the NREGA Act. The article further provides the reasons for this lacunae in the implementation of NREGA. The first reason is the lack of sufficient funds, second, the rampant payment delays, and third, the abysmal wage rate. The author further provides the causes for the lack of sufficient funds, rampant payment delays, and the abysmal wage rate. With this, we have come to the end of today's discussion. Now let us move on to the question for the day.